welcome back to my channel. Today in this video we will cover emergency provisions, all the important aspects quickly. Emergency provisions are contained in part 18 of the Constitution from article 352 to 360. There are three types of emergencies: national emergency, constitutional emergency or president rule, and third is financial emergency. There are three grounds on which national emergency can be declared: war, external aggression or armed rebellion. Earlier, third ground was internal disturbances. 44th Constitutional Amendment changed it to armed rebellion. The 38th Constitutional Amendment Act 1975 made the declaration of national emergency immune from judicial review. But the 44th Constitutional Amendment removed this part. Also, the Minerva Mills case in 1980 declared that proclamation of national emergency can be challenged in the court. Parliamentary approval. National emergency, if declared by President, must be approved by the Parliament within 1 month, and if in that period of 1 month Lok Sabha gets dissolved, then the approval must come within 30 days after the first sitting of the new Lok Sabha, means after reconstitution. And in the meantime, Rajya Sabha must have approved it. National emergency can be extended for 6 months at a time to an indefinite period of time, but it requires approval every 6 months. This periodic approval was included by the 44th Constitutional Amendment Act, and this approval must be passed by special majority, means every resolution approving the proclamation of emergency or its continuance must be passed by either House of Parliament by a special majority, that is, a majority of the total membership of that house, and B, a majority of not less than 2/3 of the members of that house present in voting. 42nd Constitutional Amendment Act enabled the President to declare emergency to only a part. Through 44th Constitutional Amendment Acts, certain limitations were put so that this provision cannot be misused. First, that emergency can be declared only on written recommendation. It must be periodically approved, and the approval must pass with special majority. So even the periodic approval also pass with special majority. And revocation by resolution. If Lok Sabha wants to revoke it, they can pass a resolution by simple majority, and then national emergency must be revoked. A president can revoke a national emergency at any time, and such a proclamation does not require the parliamentary approval. So there are two methods of revoking the emergency. First, the president revokes, and second, the Lok Sabha passes the resolution with simple majority. What are the effects? On three different aspects. First, executive. The center acquires all the power if there is national emergency. The legislative power of state are not suspended, but the center can reserve the bills for the reconsideration of president. If any bill is passed by a state legislature, the center can reserve that bill. And the president can also modify the constitutional distribution of revenues between the center and the state when there is a national emergency. Fundamental rights. As we learned in the chapter of fundamental rights, when there is national emergency, the 6 fundamental rights under Article 19 are automatically suspended. However, only when the national emergency is declared on the grounds of external aggression, then only it can be suspended. And this was included by the 44th Constitutional Amendment. Also, the fundamental rights are not suspended, but their enforcement are suspended when the national emergency is in force. We cannot go to the court at that time. Article 359 authorizes the President to suspend the right to move any court for the enforcement of fundamental right during a national emergency. Fundamental rights per se are not suspended, but their enforcement are suspended under Article 359. Second type of emergency is President's rule. Breakdown of constitutional machinery in the state, then President's rule is declared. Article 355 says that it is the duty of the center to see that government of every state is run according to the constitution, and when the state fails to do so, then president rules can be declared. A president can declare president's rule even without the governor's report. Article 365 says that if state fails to comply with the center's direction or instruction, then also the center has the right to declare that the constitutional machinery has broken down in that state. So 3 articles are important here: 355, 356 and 365. The difference between parliamentary approval in national emergency and in President's rule is that in national emergency we require special majority for approval as well as periodic approval. But in President's rule, a simple majority is required. While in national emergency, 1 month time period is given. In President's rule, 2 months time is given. And the same thing applies that if in between that 2 months, Lok Sabha gets dissolved, then within 30 days after its reconstitution, the Lok Sabha must approve it. Meanwhile, the Rajya Sabha must have given the approval. The President's rule can be extended for 6 months at a time and 3 years is the maximum period. Through 44th Constitutional Amendment, a protection was included that beyond 1 year, extension of President's rule can be done for 6 months at a time. And there are two conditions for it. First, that there is a national emergency in the country. In that case, President rule will continue in any state if there is. And if the Election Commission certifies that election cannot be held there. In only these two conditions, beyond 1 year, a President rule can extend in a state, that too 6 months at a time. The Bommai case of 1994 further laid down certain propositions for President's rule under Article 356. First, that the President rule is subject to judicial review. Second, there should be relevant material available that a constitutional machinery has broken down in that state, and the center has the responsibility to provide this relevant material. Burden lies on the center to prove. Fourth, the court cannot go into the correctness of the material or its adequacy, but it can see whether it is relevant to the action. Fifth, if the court holds the presidential proclamation to be unconstitutional and invalid, it has power to restore the dismissed state government. Sixth, the state legislative assembly should be dissolved only after the parliament has approved the presidential proclamation. Until such approval is given, the president can only suspend the assembly. In case the parliament fails to approve the proclamation, the assembly would get reactivated. Secularism is one of the basic features of the constitution. Hence, a state government pursuing anti-secular politics is liable to action under 356. If a state government loses the confidence, then it should be decided on the floor of the house. A governor should not decide whether the state government has lost its confidence. It must be proved on the floor of the house. When a new political party assumes power at the center, it will not have authority to dismiss ministries formed by other parties in the state. And the power under Article 356 is an exceptional power and should be used only occasionally to meet the requirement of special situations. So these were the propositions that were laid down in S.R. Bommai case 1994. Finally, we have financial emergency under Article 360. Again, similar to President's rule, 2 months time is given for approval. However, it can continue for indefinite period of time until it is revoked, and the approval requires only simple majority. And President can revoke it anytime he likes. And one important thing in financial emergency is that no periodic approval is required for its continuation. What happens during financial emergency? The center can direct any state to observe financial propriety. Salaries can be reduced. The president may issue directions for the reduction of salaries and allowances of persons serving in unions. The salaries of judges of the Supreme Court and High Court can be reduced. So these things can happen when there is financial emergency. During the operation of a financial emergency, the center requires full control over the states in financial matters. Some previous year questions that were asked on emergency provisions. Consider the following statements in respect of financial emergency under Article 360 of the Constitution of India. Let us check what we read today. A proclamation of financial emergency issued shall cease to operate at the expiration of 2 months unless before the expiration of that period it has been approved by the resolution of both houses of the Parliament. If any proclamation of financial emergency is in operation, it is competent for the President of India to issue directions for the reduction of salaries and allowances of all or any class of persons serving in connection with the affairs of the Union, but excluding the judges of the Supreme Court and the High Court. We just read that the salaries of Supreme Court and High Court judges can also be reduced. So this statement is not correct. Statement 1 is correct. Answer will be 1 only. Next, the term of Lok Sabha cannot be extended under any circumstances, can be extended by 6 months at a time, can be extended by 1 year at a time during the proclamation of emergency, can be extended for 2 years at a time during the proclamation of emergency. We did not read what is the effect on the life of Lok Sabha when there is emergency. This is what happens when you solve a question. You find that what is important in a topic. When there is a national emergency in operation, the life of the Lok Sabha may be extended beyond its normal term by a law of parliament for 1 year at a time for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. For example, the 5th Lok Sabha 1971 to 1977 was extended 2 times by 1 year at a time. So the answer will be C, can be extended by 1 year at a time during the proclamation of emergency. Similarly, the parliament may extend the normal tenure of a state legislative assembly by 1 year each time for any length of time during a national emergency, subject to a maximum period of 6 months after the emergency has ceased to operate. So this was all about emergency provision. I hope I was able to cover all the important aspects of this topic. If you want me to make more such videos, let me know in the comment section, and do subscribe if you are new here. It gives me a lot of motivation to upload new videos and new topics for you daily. Thanks for watching. Have a nice day.